please. Thank you. All righty. Thanks, Brett, for that introduction. Again, my name is April Holland. I'm a corporate attorney at Miller Martin. I've been with them for about 3 years now. I have a law degree from Washington and Lee from 2010. Also got an LLM, which is a Master's of Law in European Economic and Financial Law. Most of what I do is kind of corporate mergers and acquisitions work. It's probably about 80% of what I do on a day-to-day basis. But in my spare time, I really enjoy helping startups and getting in the technology scene in Chattanooga. And you know, it's been very rewarding. And I was very thankful for Brett for inviting me here today. So let me start with, I can just use the, okay, perfect. So I wanted to just give you guys an overview of what we're going to talk about. I know that you all are probably, some of you are, you know, independent developers that do freelance work. Some of you are probably with, you know, dev shops, small and large, or some of you may even be corporate, you know, sort of developers in the corporate world. So could I just get a show of hands so I know who I'm talking to? You know, who's freelancing and independent? All right, and who's dev shop work? Okay, and corporate setting? All right, so that's a good mix. I mean, it's pretty much, you know, equal thirds there. All right, well, so I wanted to give you guys kind of first off like an overview of how business intersects with the law, because a lot of times when people think of lawyers, they think, oh, they're the ones going to the courthouse, they're arguing, you know, what you see on TV. But a lot of what I do, I mean, it's really everything outside of the courthouse. So any of your corporate documents, any of your contracts that you're negotiating with third parties, protection of IP, dealing with regulatory agencies, that sort of thing. That's what I do. So I thought it would be helpful to just give you all sort of the 40,000-foot view, bird's eye view of where business intersects with the law. Then I'd like to go into limited liability companies. If you haven't formed, for those freelancers, if you haven't formed an LLC, I'd strongly encourage you to do so. And I'd like to take you through setting up a single member LLC, which is probably the most useful for you guys here. But if you're in a company, and if you're in a dev shop and you're in charge of kind of corporate organizational structure, I will touch on some, you know, best business practices from a legal perspective of what you need to think about as you're going about your day-to-day operations. Then thirdly, I've also passed out this services agreement. It's a basic form of agreement that I'd like to be able to give to you all to use as kind of parting knowledge here today. You can tweak this form however you'd like, whatever's relevant for you, you can delete. We'll talk about each provision or most of the provisions in this agreement sort of one by one so we can really dig in and get deep with this. A lot of it's legalese and sometimes it's hard. You might gloss over it, but I'd really like to get in the weeds with you on that and just take you through each provision. Finally, I'd like to share with you all just some good resources. A lot of you are obviously very savvy with the web, so you can find a lot of this information online, you know, either with regulatory agencies or, you know, the Secretary of State's website. So you all can really empower yourselves to think about kind of legally how to protect your business. And then finally, I'd just like to open it up for questions for you all. So here, I'm sorry for the, it's probably very small on this screen here, but this is kind of, there's the formation stage at the top, early operational stage, and then financing, fully operational stage, and then exits is kind of the business life cycle here. Obviously, there's, you know, iterations of that, and you can change, you know, you can go from fully operational and then financing and then back to fully operate, you know, all of that is kind of at this, you know, at the same level. Formation stage, you guys really need to think about what type of business entity is proper for your business. There's several types of entities, but I'm going to talk to you primarily about limited liability companies, since that's going to be the most applicable to you all. If you don't have an LLC, but you're already in business, you are operating as a sole proprietorship. You probably already knew that, but one thing I'd like to caution is that as a sole proprietorship, all of your personal assets are liable in any sort of litigation or dispute that you have with someone that you're involved in business with. That means that theoretically they could come after your house if you've done something so egregious that it requires them to be made whole, and you have to pay out of your own pocket for that. So after the formation stage, we've got the early operational stage, and this is, these are some general categories just to think about. It's by no means exclusive. There are many, many others, but IP, you want to obviously think about trademarks, copyrights, patents to the extent that that's relevant, confidentiality agreements and NDAs, I'm sure you all are very comfortable with, but it is something that you all should consider. If you have your own website, you probably already have privacy disclaimers, terms of use, and there's tons of great resources online. My husband, James Holland, who's also in the audience here, has shared with me some of the things that he's found that are applicable to developers, and it's really great if you're willing to dig in and really read and understand the materials. Where lawyers can help are kind of tweaking and customizing those forms and making sure that it's totally and entirely relevant to your business model. So, for instance, Amazon has a lot of terms about returns and about products and warranties about their products and how they interact with their third-party providers, and that's obviously not going to be relevant for somebody like a developer who's offering services primarily as their form of business. But so those are some considerations that you can, if you're working with people that are with children under the age of 13, sometimes that's an issue, and that will trigger other privacy considerations that you need to be aware of, and that's where attorneys can be helpful. Third-party contracts. This is, any sort of contract that you have with another party outside of your business. So leases for office space, service agreements, contracts for executives, if you have, a president that you would like to keep on board for a certain amount of time. This all falls under there, and I really do urge you to use an attorney when you're contracting with third parties, just to be sure that you're contracting in the appropriate way and you're covering your risks and liabilities. Obviously, insurance is very important, and I can't help you with that, but there are plenty of insurance brokers out there who be more than happy to probably go over their services with you. But just general considerations, and really pretty much every facet of the law touches business, with the exception of maybe family law and domestic relations. So, there's a lot here, but you can go over this slide at your leisure or not. But wanted to give you guys just an overall sense of what's going on here. So limited liability companies. Limited liability company is a structure that has been basically formed by law. It's an entity that acts as a person, so it really steps into the shoes of, you're creating a new person when you create an entity. An LLC, is more flexible than a corporation. Corporations tend to have a lot of recording requirements. You have to have a board when you have a corporation, which just creates another layer of complexity when you're with the record keeping components of all this. But it does afford you limitation of liability, which is absolutely important for you as business owners to separate yourselves from the liabilities of the business versus your own personal liabilities. if you contract with a third party and you've done something, grossly negligent, and they come after the company, I mean, that's where it stops. So your own personal assets are protected in this structure. Another advantage to an LLC is that you have a lot of ways to kind of structure it. I mean, if you want it to function like a corporation, you absolutely can make it look like a corporation. That's not a problem. You can also make it very simple, sort of like a partnership. General partnership is basically you with another person operating a business, but not filing anything with the Secretary of State, not doing anything, formal. And that is also dangerous because you can run into problems where your partner agrees to do something and on your behalf without your knowing, and then you then become subject to that liability of your partner. So that's kind of a danger there, but LLCs will cover you. If you do this, you'll be fine. The cost is at least $300. That's generally what it costs. But for, certain members, I gave you a sheet that has a fees schedule with the Secretary of State, and it'll kind of outline, the different levels of fees for you. Let's see. So there are 3 general structures of a limited liability company. You can be member managed, manager managed, or director managed. And you've probably heard these terms thrown around before. Member managed is what most people are going to want in this audience probably, because that's really resting all of the responsibility of running the business with the members. You don't have to create this artificial level of a board, which also has officers, and then officers can hire employees and that sort of thing. Member managed is probably the way to go, but I will show you how these kind of structures look. So they're a little different. So this is member managed. Members, they make all the decisions at the top. They can then, and they have to really designate a president and a secretary to go about, doing the day-to-day, signing documents, opening a bank account. And these officers can actually be the members of the LLC. So there's no problem there. It's just that there's a distinction of which capacity that you're acting in, whether that's as a member or as an officer. And sometimes that can be a little bit confusing to people, but just wanted to make that clear. Officers do not make decisions for the company. They can only do what has been delegated to them by the members. But when it's the same person, it kind of gets blended together a bit. Board managed LLC. So this is going to be a structure that looks exactly like a corporation generally. You're going to have your members. Members are essentially shareholders in this case. Actually, in any LLC case, members are shareholders. The members then elect the board. And again, the board member, can be a member. It's fine. But then the board then has to appoint a president and secretary to go through this. So see, there's an extra layer here, and the board is actually charged with the obligation of running the day-to-day business, making decisions for the company on behalf of the members. So it can be a little sticky. This is really a good structure for people who have investors who want to have a decision-making role in the company, but they don't want the corporate structure, which is a little bit more rigid. So it's probably not relevant for you guys. Manager managed is basically the same thing. The only difference between manager managed and director managed is that a manager managed company can have just one manager in charge of everything. So you sometimes see this in companies that are like investment vehicles, and you'll have the members designate a manager that's then charged with all of the decision-making capability of the company. Members can then only do very limited things like dissolve, approve the dissolution of the company. But the manager does everything, and the manager can then appoint a president and secretary similar to the board managed entity. So now with that basic outline, I'd like to just go over very quickly with you all the setup of a single member LLC. Do people in this room have LLCs already, or do they not generally? Who doesn't? Oh, wow. Okay, great. That's great. I mean, I assume that many of you probably want to set one up, and I'd like to share with you how to do that on your own so you can save some money. A lot of this stuff, you pay LegalZoom $200, $250 to help you set up something that you can actually do entirely yourself. You could pay someone like me or one of my colleagues probably $1,000 to do this, and it's a lot better if you are empowered to do it yourself, I think. So step one, entity formation. I'm going to go over this generally as if we're not in Tennessee, but this is totally, I will make some parallels with Tennessee so that you all can follow along. I know some of you probably live in Georgia, and if you do, that's fine. If you want to run the principal operation of your business in Georgia, I strongly suggest that you form your LLC in Georgia. If you are principally located in Tennessee, then the same goes there. I would suggest you form in Tennessee. Luckily, both Tennessee and Georgia have great online applications. You do need to be careful because there are a lot of websites out there. If you just search form an LLC in Tennessee or form an LLC in Georgia, you're gonna get a lot of extraneous sort of information and people trying to profit from, just like anything else. But you do have to be a little careful about what website you're looking for. But so the important thing to note here is to go to the Secretary of State's website of whatever state that you're forming. And sometimes that can be a little tragic. If you have seen the state of the Tennessee Secretary of State's website, they recently did an upgrade, but they've got this bright green search box at the top. And it's, visually not appealing. The optics are probably not what you'd like to see, but it does the trick. So, and I've included the website link here. And it really will take you through exactly what you need to do. Brett, is there a way to get to the, just so I can get to this website? If I click. Okay. See that green box? Yeah. Can't really miss it there. Yeah. Make it really clear. Right. 2000, circa 2000 here. The sad thing is that they redid this website this year. So what you can do, there's a couple of ways to get there. You can go up here and, business entity filings. And let's do online business services and form a new business. And I like to just take you through this so you can know exactly what to expect. So business entity type, obviously that's LLC. You have to attest that you understand that this is public information. So anything that you submit into this form is public information and can be obtained by anyone who requests it. That means that if you don't have a separate address for your business and you're using your home address, it will be public knowledge. So just to keep in mind, you might like to consider getting, okay, 15 minutes. All right, might want to consider, using an office address that you can use. All right, business name, we're just going to do domestic. It's not a foreign business. And then we're not going to make any additional designation. This is not relevant for you guys. And you don't need to click Series LLC. So it looks like somebody already has that name, but keep on going. So I like to always make this perpetual. You can also have a time limit, but it doesn't seem like you really need to. If you want to delay the effectiveness of your LLC, you can do that, but it probably is not going to be really make a difference. Here's where you can select what type of entity you'd like, and member managed is what we want to do. We're going to do one. And then you do not, these are all optional, so you don't need to click these. And then here you click, so registered agent. This one is important. You can be your own registered agent and list your address, but basically this is a litigation sort of thing. So if you get sued, somebody knows who to contact to serve process on you. You do have to put someone, you can't leave it blank. An individual is fine. If you don't want to be that person, you can designate your attorney or someone else. If you don't live in that state where you're forming the LLC, then you have to choose a service to represent you. And we typically use corporation or CT corporation or national registered agents. And you'll have all this information. I'll provide that for you, or Brett will provide it for you. So you'll have to fill in this information. Then you get, I know they're just gonna ask me to do all this stuff. Let's use, street. And yeah, Hamilton County, I suppose. And then we can also use this as the principal office address. Probably is fine. Oh my gosh. Let's see if that works. Okay.
Get that address right.
I know. Let's see, we'll just use that. Continue. That's ridiculous. All right. Sorry, guys. So then you have to submit this saying that you, under penalty of perjury, that you are who you say you are. And you print and you sign. You can sign online and also submit your form of payment. There is a service charge if you do it online, but it's so easy. It's just easy. I would recommend doing it this way. Now, one thing that everyone who forms their LLC by themselves tends to forget is that once you've received your evidence of filing, so that the Tennessee Secretary of State says, here you go, you need to take your articles of incorporation, which they will send to you, and then record it with the county register, basically of the principal place of business. So in Hamilton County, you'd register that with the Hamilton County Register of Deeds. It's $7, but you need to do it. I know people who don't do it, and there haven't been, ramifications, but that's part of the process. How do I get back to the? All right.
Should. It's trying. Takes a minute to switch over.
Oh, okay. So a lot of you, and then once you've recorded, you will need to obtain your federal employee identification number. This is not, this doesn't mean that you have employees, but it's basically the social security number of the company. You can also apply for this online at this website. It's very simple to do, won't take you through it. And then step 3, you need to consider foreign qualifications. If you're operating in Georgia and you're doing consistently sort of business in Georgia, you will need to qualify there. You can get all of that information on the Secretary of State's website in Georgia, or any state for that matter. But each state has a different definition of when you have to, what sorts of criteria you have to meet before you have to qualify there to do business. And I think the best way to really get a sense of where you need to do this is to talk to either an attorney or an accountant. And then, finally, business licenses and state taxes. You do need to get a business license wherever you're operating, whether that's county level or city level. And I've included the links there. You will probably not need an operating agreement if you are a single member LLC. In fact, I promise you, you don't need one if you are a single member LLC. All an operating agreement is the governing document between the members of the company. So it basically talks about rights and obligations of all the different members and how they make decisions. And if you're the only one making a decision, you're fine. So record keeping requirements, I would just like to impart some wisdom here about what you can do to keep your records in place. If you ever feel like you want to sell your business at some point, I absolutely think that you should follow all of these points to a T, because one of the biggest problems that I see in mergers and acquisitions is incomplete records. And you will find that is very sometimes difficult for companies that are purchasing, buyers that are interested in your company. They will want you to either recreate those documents or give them some sort of assurance that you ran your business accordingly and properly. So organizational documents, this means that you need to create written resolutions at least annually that appoints your officers, approves your annual report that you submit to the Secretary of State, and approves distributions to the members. I also handed out a form of written resolution to you all, and that is something you can use if you'd like as when you initially form your company to elect officers. Agreements, keep all your executed agreements, your signed agreements with third parties in an organized way. Make sure you sign your agreements and you get signed agreements. That's another big point that we see a lot of unexecuted agreements, and that's challenging for us as attorneys. Pay your taxes. Pay your taxes with the Department of Revenue in Tennessee. Pay them locally at the city level. Pay them where you're supposed to pay them. And then finally, if you have an assumed name, so let's say I'm ABC LLC, but I want to operate under April's Donuts, then that's what I'm just thinking about right now, donuts. Then I would need to file basically what's called an assumed name filing. It's called doing business as. So you'll sometimes see ABC LLC, DBA, April's Donuts. And that's basically just letting people know that the legal name is ABC LLC, but you do business and you represent yourself as April's Donuts. So you can find that information online as well. I'll skip this on the corporate veil since we are probably running out of time. So wanted to switch gears to the services agreement that I handed out to you guys. One word of, some of you probably are very familiar with agreements, but for those of you who aren't, I'd like to just make a quick analogy to, sort of writing and drafting legal documents with developing work or developer work. You know, with variables, you assign certain characteristics to a variable. Well, we have what's called defined terms. Defined terms are any capitalized term in quote marks. So agreement, service provider, and client are all defined terms in this section. Basically, what you're doing is you're attributing whatever's prior in the prior clause right before that parentheses to that word. Sometimes you'll see it in a glossary, so you'll have a glossary of defined terms of an agreement, but a lot of times you'll see it just embedded right here in the draft. So, so any further reference of agreement, service provider, or client throughout the rest of the document will refer back to wherever it was first defined in the agreement. So just to kind of conceptualize it that way might be helpful. So in the preamble, you know, this is really where you identify the date, the name of your business, the state of formation, and the type of entity that you are, and then the parties that are entering into the agreement. It's pretty simple. Recitals. So in the recitals section, this is where you give background on the scope of your arrangement. It's not usually binding unless you make it binding, but it just gives the reader background as to what went on before you contracted, or what's going to happen. That's all kind of incorporated in the recitals here. And so you'll see these whereases, and you know, then now therefore signals the actual agreement. Services, I've just basically copied what you have in front of you up here, but I mean, so I don't know what you guys are typically using, but sometimes I'll see statements of work, proposals, you know, one-pager kind of term sheets that developers will use with their clients, and that's fine if it's, as long as it's getting the job done. But what I like to see that's a little bit more cleaner is something like this services agreement. And the services agreement goes, you know, kind of outlines all the roles and responsibilities, compensation, ownership of the work, that's the work products that's produced, you know, confidentiality, if there are certain confidentiality things to consider, you know, indemnification and limitation of liability, which just means, you know, who's responsible for what risk when something goes wrong. And then, you know, the term of your arrangement. And so it's really a clean way of doing it. This form that I gave you is not even 4 pages, it's almost 4 pages long, if you don't include the signature page and the scope of work in the back. But really, the work section is where the obligation sort of arises and where it forms. So the client is engaging service provider as an independent contractor to perform the work that they've agreed upon in the scope of work. Now, if you've agreed to do something a little bit different than what you've, you know, you think that the specifications are very particular, you can include Exhibit A, which is at the back, a scope of work that goes into all of the particulars. I know a lot of times I'll see specifications, like, you know, for a certain app, and that absolutely should go here. And then if it's like a specific work product, so, you know, a website, or if it's just the back-end development of a database, or whatever it is, you can get very specific and technical in this area. But I like to put it in this scope of work as Exhibit A to try and keep it a little bit cleaner in the body of the draft, just so that we're very, you know, clear as to where the legal obligation is versus where the actual work obligations are. Compensation is the same way. This is just this is the text here is really just the legal obligation to pay. But then you can include the details and the payment schedule as you like in the Exhibit A scope of work. ownership. Now, this is the big one for you guys. Ownership of the work product. It's really important that you guys cover this and make it clear. I mean, probably it's more important for your clients that this is clear, but you want to show that you're being proactive in thinking about these things. So this provision that I provided in the services agreement covers works made for hire. You might have heard that term. Basically, all that means is that the work essentially immediately vests into the client. So they have ownership of that work. You don't have to assign it. You don't have to do any sort of other intricate sort of legal work to try and to change ownership of that work product. But in case that you don't, it's important to also have these what's called a further assurances clause. And this further assurances clause really kind of says if client is not comfortable or feels like they need to further perfect their ownership of the work product, you service provider will do whatever it takes to do that. And I think that most clients appreciate that, and normally it doesn't come up ever, but it's good to have it in the document. So sorry for the small text again, but this is actually not in your agreement. So when Brett distributes the PowerPoint, if you would like, you can lift this language out of the PowerPoint and put it into your own agreements. Basically, limitation of liability and disclaimers, they go hand in hand. It's about, how much are you willing to stand by your product? So, are you going to give them full warranty over everything you've done, or is it as is? I mean, do you provide your code as is? And if there are any bugs, oh well. And what I particularly like about this disclaimer clause is that it contains a language where it says all open source components and other third-party materials are provided as is, and any rep or warranty concerning them is between the client and the third-party owner of such open source materials. Just because you don't want to be stuck with them saying, well, that's open. I mean, you put this whole thing together. Why isn't it working? And it's because another component that you didn't develop was acting up. Limitation of liability. This is how much you're really liable to the client. So the bold text here, you can include something like this, which is essentially a cap. So in no event will any amount paid to client for liability for the service provider to pay to the client will exceed 6 months, preceding invoices. So you can limit it like that as a cap, or you can also have specific language here about, these particular types of legal damages, which is fine too. It's totally up to you all. Indemnification, this one kind of sometimes gets confused with limitation of liability, but this is basically how much you're willing to, be responsible to the client for things like negligence or gross negligence or things that are probably not so relevant for the developer world, but but this is a one-sided indemnification clause. So really the client is indemnifying you for any sort of bodily injury, or if they breach any representation or warranty that they've made in your agreement about what they're providing to you, service provider. Okay, so best practices, get your agreement executed. I know I've said that, but that's very important. PDF is how we do it these days. This is totally fine. But if you can get a hold of a hard copy, that's even better. Keep your records with your client of all communications. You want to be sure that if any sort of dispute arises, that you have documented emails where you've agreed to certain provisions. Because if you don't have it in writing, it's very hard to prove later. And then finally, update and review your contracts periodically. This contract is set to be an evergreen contract. That means that it will not expire until it's terminated by one party or the other. You know, take a look at it. Maybe things have changed. Maybe you've run into a problem with your client that, you know, something you recognize that you need to cover and in the agreement, and that's totally fine to amend and restate your services agreement. Or if you have another scope of work and you want to add a new one, you can certainly add, you know, multiple scopes of work to this agreement. And then finally, some good resources. These are just basically the links that I've already shared with you earlier in the presentation, so you'll be able to access them at your leisure. And I wanted to leave you with some final kind of scenarios of when to consult an attorney, because I know that sometimes it's, you know, I get the question a lot, when is it really relevant for me to come talk to an attorney and spend a lot of money on, spend a lot of money on legal services. And I mean, I really believe that when there are third parties involved, whether that's when you're working with partners, when you're working with outside, you know, clients, or just contracts with manufacturers or contracts with, you know, banks or landlords, that you come and talk to an attorney about those documents to be clear, you know, that you understand what the obligations are and what you know, they're asking you to do. So again, signing complex agreements, and then if you're working in an LLC where you have an operating agreement and you haven't looked at it in ages, but you have new members who are joining, that's a good time to come see an attorney and say, can you help us draft this agreement so that it adequately represents our interests correctly? Financing terms and conditions, you know, if you go to a bank for loans, or if you're doing any sort of fundraising in whatever manner, I'd suggest talking to an attorney. I'm taking a website live, you know, IP questions, and I'm not probably the best, full disclosure, I'm probably not the best person to talk about complex IP issues, because we do have people at Miller Martin who specialize entirely in IP, and they can answer all your questions about, you know, patent applications and that sort of thing. Obviously, when you have a dispute with somebody, you come to an attorney to get advice, or if you want to sue someone, it's always good to consult an attorney, not me, but a litigator for that matter. I think that was it for what I wanted to cover. Oh, you know, when you're choosing an attorney, I would say make sure that you're looking for somebody who really you connect with as a person. A lot of people put a lot of great weight into names, and of course, you know, brand name attorneys are always good generally, but you might not feel comfortable with that person. And then, you know, I'm usually pretty good about telling people when I don't know something, and I try to make that very clear up front, that if you've presented me with an issue and I'm not, and I don't feel prepared or you know, knowledgeable enough in that area of law to advise you, I absolutely say that, and I bring that forward and say, you know, I don't know if I'm the best person, but I can recommend somebody in town who can do that. And some attorneys aren't, maybe they don't want to admit their weaknesses, but I think that to have somebody who's willing to do that is important. With small shops, you're going to get lower rates, of course, but they might be generalists, so it might take them longer to do what you want them to do. With bigger, larger law firms, you're going to pay for overhead because you've got staff and resources available to you. But it's, you know, it's obviously a very personal decision, and you know, it's just like choosing a doctor, really, I guess, because you want to be comfortable with that professional and want to be able to trust them completely. So with that, I guess I'll close and see if you guys have any questions. Sure.
I don't know if you're the one that asked this, but what kind of tax ramifications is that have for someone like me that when I do freelance work, I'm doing it under the sole proprietorship. If I switch it going into that LLC mode, what's going to happen with taxes? Like, do you have any kind of general?
Yeah. So you will have to pay what's called a franchise and excise tax to the state. And that's really, it's a calculation that you can actually find that equation online to determine. It's based on the assets of the company. So you will have to, there is some sort of tax involved, but usually your tax accountant can answer that for you. That's a good question for them.
In addition to that, it also is separate, though, now that it's LLC, from your personal tax, income tax that you do at the end of the year. So it's give and take.
Yeah, because it is an LLC is what they call a flow-through entity. So if you have, if you're receiving, if your LLC is making profit, you'll get what's your tax accountant will prepare what's called a K-1, and you'll just file that with your personal tax return.
I know the answer to this circa 1999, but currently, if I sell a website or sell code, is that a sales taxable event in Tennessee if I'm not just doing work for hire by hour?
So if you're selling code,
In 1999,
yeah.
there's an exception that we worked through Carl Hartley and lawyers and all that, and got it declared that no, it wasn't, but I've heard that that has possibly changed.
Yeah, and I think it will depend on kind of the nature of how you're packaging that. If it's part of a service that you're providing all together, like as a finished product, that's probably considered services. But if it's a code that you're kind of packaging and then giving to other developers to use, it might be considered something else. But that's a great question, and probably somebody should look into that deeper.
Well, asked you about that question. I see they can apply that ruling differently.
Yeah, it tends to be very fact specific. So, yeah. Sure.
On some service agreements in the past, I've seen that they take the right side column space to supply like summaries of paragraph right there. Is summarization like that dangerous?
Yeah. I think it's useful for clarification if you're like internally, but I don't recommend it if you're going to be using it with a third party and that you're, signing that agreement basically, because that creates an ambiguity. If you didn't summarize it if you left out some important parts or, worded it a little bit like slightly differently, that can be interpreted in a different way. I've
actually seen that as a agreement to terms on a website.
Yes. Yes.
So that would actually be no go.
I mean, yeah, and that is where I've seen it too, is on terms of use for websites. And I think that's helpful for mass consumption. So obviously the people that are using the website are not signing that agreement. And so it depends on your audience. So, they can decide if they want to access the website again or not. But if it's something that you're signing that is negotiated, that is something with your client, just specifically, I wouldn't do it. Yeah. Any other questions? Go ahead.
There was a certain small company here in Cleveland, Tennessee, who's recently gotten into trouble over misappropriation of the veil between personal property and corporate property. Are there any particular things that are high level that you should avoid, behaviors you should avoid to break that?
Yeah, and sorry, I was going to cover that. Yeah, and I skipped over it, but let me flip over. So I have, let me see if I can pull it up really quick. Yeah, so see that signature block here where it says example ABC LLC. The biggest thing that I see is that people will sign their agreements in their own name instead of obviously the company's name. So it might say, you know, ABC LLC in the preamble, but on the signature block, it just says, you know, their individual name and they sign. So, you know, being very careful and mindful of who's actually signing is a big one. But then also, you know, it's commingling of assets. And so you want to be sure that you've really separated what's personal and what's related to your business. You want to have separate, you know, what's probably obvious to us, but, you know, separate accounts for your business and for your personal assets. And, you know, just keeping all of your records. So if you make a distribution to yourself as a member, that's fine. But, you know, properly documenting that so that it's not so fluid. You know, you're just taking money out of the company whenever you feel like it. It's, you know, if you have a set schedule like quarterly distributions or monthly distributions, however that is, you know, make sure that's in a written resolution somewhere in your documents. But yeah, that's a big one. People can get in trouble. I mean, courts are generally they disfavor, you know, piercing the corporate veil, but they will do it in cases of fraud and where it's just particularly egregious. You had another question?
Well, I just wanted to tell, because I know some of you guys have to go back to work, so don't feel uncomfortable if you have to head out. So please, you know, feel free. I don't know.
Yeah, that's it.
Under the gun for time or anything. In terms of you can get
Oh yeah, it is one. Yeah, probably need to head back.
But for those who need to leave, feel free.
Yeah.
If you want to ask a question, maybe we have time for one more.
Yeah,
Or-
one more.
Yeah, one more, two more.
As a person who works from home, the agent that where you list a contact is,
Yep.
can you put your home address in there?
Yeah, you absolutely can. It will be on public record. But that is fine. People do it all the time.
So suite home or not apartment.
Yeah. Well, thank you guys. I really appreciate it. Thanks for having me, Brett. And if you do have any questions,